is an alliance of nonprofits in Montgomery County. Currently, we have close to 180 members. We offer capacity building programs, advocacy on behalf of the nonprofit sector, and other trainings, including right now, crisis response trainings. Today with us, we have two partners from Potomac Law Group who are serving the human resources and employment law practice. They also are on the newly formed COVID-19 task force at Potomac Law Group, and they are offering their services to us pro bono today to answer some questions. They said they've been helping with everything from federal relief efforts to pivoting workforces to teleworkforces to devising a strategy for how to get back to in-person work when the time comes, how to deal with furloughs, layoffs, salary reductions, and all the things that many of you are dealing with for the first time, or if you were a nonprofit here during the last recession, unfortunately for the second or third time. This time feels very different to all of us, and it was incredibly generous that both Isaac and Wendy were willing to beam in. Wendy is a local Montgomery County woman, and Isaac is coming in from New York to share with us some of the questions that they've been receiving from their clients and offer some strategies to us going forward. There are about 20 of us on the call, so it shouldn't be too unruly, but I'm just gonna ask for you after their brief intro to go ahead and chat any questions in the chat box. If you'd rather just explain it yourself and be unmuted, then just go ahead and put that in the chat box and I'll let you know when your turn is up. We'll try to keep this as informal and question and answer as possible, but I do think with so this is a little bit more technical than some of the webinars we have, so it would be good to make sure that everybody has an opportunity to hear and be heard. So with that, Isaac, Wendy, thank you again, and take it away.
All right, well, thank you very much for the introduction. So, look, we are all obviously facing very challenging economic circumstances, and many nonprofits are thinking about furloughs and layoffs and salary cuts and all other possible cost-cutting measures. Of course, none of us enjoy this topic. I normally, when I do a presentation, I like to start with something humorous, something to sort of engage the group, and I just thought it was completely inappropriate for a discussion like this, where we are talking about, such a difficult topic and a topic that I certainly don't take lightly and no organization takes lightly. I hope for all of our sakes that as the economy reopens, our theme will turn from layoffs and furloughs to onboarding and hiring, and we can all move forward in a much more positive direction. In the meantime, we face some difficult decisions to cut costs. What complicates things in today's climate is a number of new federal programs, such as the Paycheck Protection Program, paid sick leave programs, expanded unemployment programs. These are all very new federal laws, and they all have significant implications for our decisions when it comes to payroll cuts and furloughs and layoffs and other cost-cutting measures. So our goal today is to explain the things you should be thinking about, to help you, of course, navigate the new government programs and to answer all of your questions. So let's begin with some definitions, just so we are all sort of using the terms in the same way. So first of all, what is a layoff? A layoff, it's a type of termination that is usually performed to cut costs, and a layoff is a complete separation from the employer. So it often comes with a severance package where the employee signs something basically saying they won't sue you, and it's a complete separation. A furlough is very, very different. A furlough is a temporary unpaid period. The employee stays on your payroll, they are still your employee, but they don't work and you don't pay them for some period of time. Now, a payroll cut, as the name suggests, means keeping your employees working, but reducing their hours or just reducing their pay without reducing their hours, while they are still actively your employees. Now, this could mean, for your hourly employees, it could mean reducing their hours. For your exempt employees, your salaried employees, this could mean either reducing their pay without reducing hours or converting them to hourly employees, and we will talk about all of these options. Before moving on, I should just mention one point. Sometimes people use the term furlough to refer to a temporary reduction in hours. To keep things simple, for this discussion, when I use furlough, I mean a completely not working, and not having reduced hours or anything like that. And reduced hours, we will talk about in terms of payroll cuts, and furloughs mean a complete separation for some period of time. So now, what considerations should employers take into account when considering furloughs versus layoffs? From the standpoint of your employees, furloughs tend to be much better received than layoffs. Furloughed employees, they retain their health insurance, they retain their benefits, they also know that they have a job waiting for them when business picks up. And really, they haven't lost their job, they're just not being paid for some period of time. It's obviously not good, it's not something people want, but it tends to be a softer measure than a layoff. Layoffs, as I mentioned before, those are a complete separation from the company. While layoffs can be temporary, employees often don't view layoffs as having any guarantee of returning to work. And laid off employees, for that reason, they often start looking for other jobs. As I mentioned, laid off employees, they will sign a separation agreement. Sometimes their email address is turned off, they return their ID card and their work computer. They are leaving your employment. And if you bring them back, you have to go through a whole onboarding process. And of course, it's good for employers to retain employees because these are people who know your culture, they know your other staff, they're people you don't need to retrain. And with layoffs, it becomes more likely that an employee will be lost to you. Now, of course, an alternative to layoffs and furloughs is conducting payroll cuts. The easiest way to cut payroll is for hourly employees. For hourly employees, employers generally just simply have the flexibility to reduce their hours, reduce their pay, and it's a very simple process. For exempt employees, and exempt employees, these are the people who you have on salary. They earn a fixed amount for every pay period. Things for them are a bit more complicated. As an employer, you have to pay an exempt employee the same amount for each pay period in which they work, regardless of how much they actually work. So for example, for an exempt employee, you cannot say to them, okay, guys, this week things are slow, so we're only going to have you work 3 days this week, and we're going to pay you only for 3 days. You can't really do that with exempt employees. So what can you do with exempt employees to cut salaries and to make pay cuts when needed? Option one, you can have them work fewer pay periods while fully paying them for the pay periods in which they do work. So now, if an exempt employee works even 1 hour during a particular pay period, you must pay them. But if you have an arrangement with them where they work every other pay period, meaning in this pay period, they are completely off, no work, no email responses, nothing, but next pay period, they work again, you don't need to pay them for the pay period in which they're not working. Now, another option you have with your exempt employees is with or without reducing their hours, you are allowed to make a reduction in their salary due to an economic slowdown if 2 conditions are met. So again, for exempt employees, regardless of whether you cut their hours, you can cut their salary if 2 conditions are met. Number one, the reduction is not related to the quality of their work or the quantity of their work in a particular week. And number two, the reduction is in place for a long period of time, meaning you should view it as a permanent measure until the economy recovers or until some future time when you can pay them their old salary again, but it should be seen as basically a permanent measure. The other option you have is to take your exempt employees, your salaried employees, and switch them to non-exempt status. That means that you would have to pay them overtime. But the whole point of switching them is that they probably don't have very much work to do. So it's unlikely that you would have to pay these people, overtime. You would reduce their hours and they would make less. Keep one thing in mind. For an exempt employee to stay exempt, their salary needs to exceed $684 per week. If their salary falls below that amount, that's when you would need to switch them to hourly work. And note that in Maryland, you need to give employees 1 full pay period of advanced notice if you are going to cut their pay. So the notice requirement is something to keep in mind. Now, I am sure that many of you on this video call have either applied or successfully obtained PPP loans, the Paycheck Protection Program. So how do these loans play into all of this? Because obviously they have implications for these decisions. So the PPP loans are forgivable if they are spent on payroll, interest on mortgages, rent, or utilities. There are 4 categories. They can be spent on other things that are not forgivable, but if you spend them only on those 4 things of payroll, interest on mortgages, rent, and utilities, those loans are forgivable. For the loan to be fully forgivable, there are 2 very important requirements. Number 1, and I don't want to get too far into the weeds, but in broad brushstrokes, number 1, your number of full-time staff in the 8-week period following receipt of the loan cannot be lower than your number of full-time staff during some optional reference periods that they give in the law. So in other words, what they're saying is the goal of this program is for you not to reduce your staff. So if you have reduced your staff as compared to certain time periods that you can choose from that are stated in the law, if you do reduce your staff compared to those time periods, the forgivable amount is reduced. Now, along the same lines, no individual staff member's salary can be reduced by 25% or more compared to the most recent full quarter in which that employee worked. So now, if you cut employee salaries by 25% or more, 24%, no problem, 25% or more, or if you reduce your number of full-time equivalent staff members, the forgivability of the loan goes down. So some amount could still be forgiven, but it won't be the maximum possible amount. Now, for some organizations, it is more valuable to have the loan right now and have a loan at a favorable interest rate that is paid off in the future, and to use that money for the allowable purposes of the loan. It's more valuable to have that than to get 100% forgivability by maximizing payroll. So if that's the case, you can certainly use the loan as a loan. But if you want the loan to become a grant, if you want the loan to become forgivable, or at least a large part of it to become forgivable, using it on payroll is a very good way to get there. Now, another sort of common set of considerations about all this is the Families First Coronavirus Response Act, the FFCRA. What that law does, or what it's intended to do, is it creates 2 federal paid leave programs. The first is called the Emergency Paid Sick Leave Act. That program provides 2 weeks of paid leave to employees who cannot work and who cannot work remotely in certain situations, such as a government-ordered quarantine, a doctor-ordered quarantine, their kids don't have childcare, their kids are home from school. In these situations, they are entitled to 2 weeks of paid leave. The second program is called the Emergency Family and Medical Leave Expansion Act. And that gives an additional 10 weeks of paid leave to people who cannot work because they lost their childcare and their school is not open for COVID-related reasons. Now, employers have to pay this leave. You are the ones to pay it, but it is 100% reimbursable through a subsequent tax credit. And payroll providers are facilitating that reimbursement. Here's the thing to keep in mind. Once an employee tells you that they want to take leave for a qualified reason, at that point, you can no longer lay them off. At that point, you are obligated to provide the leave for them. But if you furlough an employee or you lay them off, and then after that time, 2 days later, they say, now I want my paid leave, right? It's too late. It can't work in the reverse order. But if they ask you first, in that case, you have an obligation to provide that leave. That leave. With that, I will turn it over to Wendy, who will explain the new expanded unemployment provisions. And then, of course, we look forward to answering your questions. So we will keep an eye on the chat, and once Wendy finishes, we'll dive into the questions. So Wendy, please.
Thank you, Isaac. So Isaac just spoke with you about the various options available to your organization if you unfortunately need to reduce your workforce in order to save funds. And I'm sure for many of you, your employees are like family, and you want to know that they have a safety net and that they're going to be okay if you need to make cuts. Fortunately, both the federal government and the state of Maryland have stepped in to provide some assistance, both to you as a business and also to the individuals who work with you who've been affected by this just incredibly massive crisis. I'm going to walk you through the various types of relief available and how they might also affect your decision-making if you're contemplating layoffs, furloughs, or salary cuts. So first, let's talk about what's available at the federal level. The CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act of 2020, which was passed at the end of last month, expanded unemployment compensation benefits in three very important ways. First, it expands access to people who wouldn't normally be eligible. Second, it increases the amount of benefits available. And third, it lengthens the amount of time that people can continue to collect benefits. We'll look at each one of those. So let's first talk about expanded access and who now is able to get unemployment benefits that otherwise would not normally be eligible. So that applies to self-employed individuals, 1099s or independent contractors, including gig economy workers who typically are not eligible for unemployment benefits. In addition, for individuals who lack sufficient work history, they're recently employed, but they just don't have sufficient wages in covered employment during the last 18 months to qualify for regular unemployment compensation, and became unemployed or partially unemployed for a number of, there are 10 listed COVID-related reasons. A lot of them happen to be the same types of reasons that Isaac just went over with the Families First Coronavirus Response Act. They may be eligible for benefits, and this includes people who have been on unemployment for a while and have run out of benefits. So what are some of these reasons? It could be, in addition to some of the things that Isaac mentioned, the employer temporarily shuts down due to COVID. Certainly people who are quarantined, caring for a family member who can't telework due to childcare or dependent care demands, such as under the FFCRA, and also people who have had to quit their job due to COVID. So for example, that might be somebody who had the illness and has recovered, but unfortunately has continuing health complications that prevent them from performing the essential functions of their job if they were to come back to work, even with reasonable accommodations. Now, just a little bit of guidance on what it means for somebody who has to quit. First, if there's sick leave or other paid leave that's available, such as under the FFCRA, then the employee has to utilize that before they can quit and collect unemployment benefits. Also, many of the reasons that I mentioned are temporary. And once the qualifying circumstances change, so the workplace reopens, school reopens, the person recovers from being sick, they can resume work. At that point, they're no longer able to collect unemployment benefits, which I guess is fairly obvious, but is something that probably bears stating. One thing that is really essential to keep in mind that the Labor Department has stressed is that quitting for the purpose of collecting unemployment is fraud. And certainly for an employer and an employee to collude in having the person quit for a COVID-related reason if the real reason is just for them to get unemployment benefits, would be fraudulent, and that could be subject to criminal prosecution. Now, a lot of questions still remain as to how states are going to interpret whether an employee has met these standards, especially as states are starting to open and isolation orders are relaxed. Here in Maryland, we can kind of look to see how that plays out in other states, but each state is going to have some discretion to interpret these provisions, and so we'll have to see how Maryland navigates this. So we've talked about who is now eligible for unemployment benefits who wouldn't otherwise be. Who's not eligible? Anybody who can telework with pay is not eligible to receive unemployment benefits. And also, as I said, anyone with paid sick leave or other paid benefits is not eligible for unemployment benefits. Now, in some cases, a person may be eligible for partial benefits if their paid leave benefits, like sick leave or the emergency leave provisions that Isaac reviewed, cover less than the individual's customary work week. The same might be true if the person's teleworking, but they can't work their normal hours because of childcare responsibilities or something else. Keep in mind also that under this portion of the CARES Act, individuals who are receiving benefits that wouldn't ordinarily otherwise be eligible, as of now, will only be able to receive benefits through the end of this year, unless, of course, Congress passes additional measures. So that's who is eligible. Now let's talk about how much they're eligible for. So the federal government, this is under the CARES Act, is expanding the amount of unemployment benefits that are already available under the state of Maryland, and I'm going to go over what that looks like in a minute. It's expanding whatever that is that people will receive by an additional $600 in weekly benefits to everyone who qualifies for benefits. There are some limited exceptions for people who receive benefits under certain programs, but in general, everybody is getting another $600 a week through July 31st of this year. At that point, the $600 will stop unless, again, Congress passes some new measure. So in addition, as I said, the CARES Act extends the amount of time that a recipient can receive benefits by an additional 13 weeks over what they would normally receive. So normally, when a person receives unemployment, it's for 26 weeks. This now extends that time period to 39 weeks through the end of this year. So for some people, and people who go on to unemployment now, the end of the year will come before the 39 weeks will end, but generally people who were collecting before will get a full 39 weeks and everything will sunset on December 31st. And this, by the way, includes the additional $600 benefit, the extended time, but only through the end of July 31st. So the $600 benefit is available both during that initial 26 weeks of regular unemployment and also the additional 13 weeks, but the $600 is going to end on July 31st. So now let's talk about what unemployment looks like in the state of Maryland, because unemployment benefits generally are administered by the state. The way that works is that your organization either pays into an unemployment compensation fund, or because you're all nonprofits, you may reimburse directly, which means that you're self-insured. That's an option for nonprofits. Now, in terms of how this is all working, you might have heard that Maryland has been having a lot of problems with its website and with the online application process. They say they're working on this, but there have been significant delays, so that's something you might want to warn employees about if they are seeking unemployment benefits, just so that they are prepared. Now, payments also may be delayed because of all the backups, but Maryland, unlike some states, does not have a waiting period for benefits. So all employees who qualify will be eligible to begin receiving their benefits starting on the day after their employment ends. It doesn't mean they'll get the money on that date, but that's when their benefits will begin accruing. Maryland also has removed all deadlines for claimants to provide documentation that would be needed to support their claims. And that's primarily because they know that they've had so many delays on their end. So how much money can an employee earn under the usual unemployment benefits before the $600 that the federal government is kicking in. So this is going to vary based on the individual's income and based on whether they worked full-time in all 4 quarters of 2019 for employees who are seeking unemployment benefits now. And if so, their weekly benefit amount is going to be roughly half of their gross weekly wages, up to a maximum weekly benefit in Maryland of $430. And then on top of that, employees will earn the additional $600 under the CARES Act through July 31st when that benefit goes away. So what does all of this mean for your planning? Well, one thing to keep in mind is that an employee who became eligible for unemployment benefits anytime on or after April 2nd will get benefits through the end of this year. So that's a helpful benchmark just to keep in mind. Some employees will actually earn more on unemployment than they would if they continue working for you. So as I said, employees in Maryland can earn a maximum weekly benefit of $430. If you take that and the additional $600 available through July 31st under the CARES Act, that takes the amount to $1,030 a week. If you annualize that out, that means that any employee who earns $53,560 or less will either break even or earn more through unemployment benefits than they would if they were still employed by you. Therefore, if you're making these decisions and you are thinking about selections to conduct layoffs, to furlough employees, you might consider how much unemployment the employee would collect as one factor in your selection decisions, and you can rest comfortably knowing that, especially for those employees who are paid at roughly $53,500 or less on an annual basis, that they're actually going to be earning more on unemployment than they would if they continue working for you. But as Isaac explained, you also have to weigh whether you need to keep your staffing levels and wages constant if you're planning to try to maximize your loan forgiveness under the PPP. Another thing to consider is whether you can get your payroll costs covered under the Montgomery County Public Health Emergency Grant Program, which I'm sure many of you have applied for. So these are all things, they sort of work in tandem, and all things to consider. And a final consideration that is not to be overshadowed is how employees seeking unemployment benefits now may increase the costs for you in terms of your unemployment insurance rates in the future. So generally, if you're an employer who pays into the fund, your unemployment insurance costs are determined by what's called your experience rating. And that is a number that's affected by the number of successful claims for unemployment benefits in prior years. Now, some states have issued emergency orders preventing employers from being penalized with higher unemployment insurance rates in future years because of COVID-related layoffs. Unfortunately, Maryland, at least at this point, is not one of them. There is some indication, though, that they may be considering creating a process for employers to apply for a waiver, and we'll just have to keep our eye on that. For now, a couple of things to keep in mind. First, there will be no increase in employers' tax rates for 2020. That's just not how it works, but you might see an increase in 2021. Now, tax rates are calculated based on benefits that have been charged to your organization over a 3-year period. So the state has issued some guidance and raised the point that most likely unemployment rates are going to be highest during 4 months of this year, March through June. That's when we're thinking that we're going to see the highest spike in unemployment rates. When you look at how your experience rating is calculated, those 4 months will only be 4 out of the 36 months that are used to make that calculation. So I think they're making the point that the impact will be diluted. That said, you probably should keep an eye out to see if Maryland institutes some sort of a waiver program, because that might be something that you would want to consider. Now, what if you are a nonprofit that reimburses directly or you're self-insured? Normally, you would be reimbursing completely for any successful claims that employees file. And that ordinarily actually results in a savings for nonprofits. But under this current situation, you can understand that it may be devastating. And so especially if you're self-insured, you may be worried about that. The CARES Act has helped to alleviate that concern in a couple of important ways. So first, the CARES Act provides for transfers to state unemployment trust fund accounts to provide partial reimbursements, which generally are going to be 50% of the amount of payments in lieu of contributions to certain nonprofit organizations between March 13th, 2020 and the end of the year. In addition, the Labor Department has authorized states to interpret their unemployment compensation laws to give maximum flexibility to relax late payment penalties and interest for self-insured employers. So there should be some leeway there. Now, whether you conduct furloughs and layoffs and how quickly you try to restore your staffing levels and all of this is a very complicated question, and it's going to depend on all of the factors that Isaac mentioned, as well as these unemployment considerations and the costs to your organization in the future. I think at this point, we can go ahead and open it up for questions.
Wendy, I'm going to start with some that had come in before. One question was, how do the increased unemployment benefits available under the CARES Act work for individuals who've been offered a job but whose start date has been postponed due to the coronavirus?
That's a great question, and it's actually something that the CARES Act addresses, or at least the Labor Department has issued some guidance on this. So normally, an individual who, normally unemployment is based on the last job that you had. So the individual would generally only be able to collect unemployment benefits if they had sufficient work history based on their last job. But the CARES Act now allows this individual, under that first part where it expands eligibility to different individuals, one of the things that it does it would allow that person to collect unemployment benefits if they were scheduled to start a job, but they either can't start because of a stay-at-home order or other quarantine order that's in place, or if the employer rescinded the job offer due to the coronavirus pandemic. So in this case, that employee would be able to collect unemployment benefits while waiting for their new job to start.
Thank you. Isaac, I think this question might touch on some of the information you were providing. Can an employer mandate that employees use their paid time off for the next few weeks? And similarly, there's one in the chat box that also has to do with vacation time too, that I can try to loop in.
Sure. So let's see if my answer to this initial question answers the other one about vacation time, and if not, we will come back to it. So, can an employer mandate that employees use their vacation time? So the short answer is yes. You can mandate that employees use their paid time off, their vacation days, for a leave period. So just note one thing, and then we'll sort of explore why an employer would do this. But note one thing. Maryland requires employees with 15 or more employers with 15 or more employees to provide 40 hours of paid sick leave. In Montgomery County, it's actually 56 hours of paid sick leave. So you cannot make employees use those 56 hours unless they're actually sick or caring for a sick relative, and those hours are hours you need to keep. But you can mandate that they use their other paid time off, for a couple weeks, for example, during this time. Now, obviously, this is not something that's popular with employees, and employers certainly don't like doing things that they know their employees won't like. So why would an employer do this? What would be the reason for an employer to do this? So first of all, if you have a written policy saying that you won't pay out unused vacation time when an employee leaves your employment, then you don't owe employees time when they leave. When they leave, their vacation time is not anything you have to pay them for. But if you don't have that written policy, if you have no policy on this topic, then employees who you lay off are entitled to the cash value of their unused vacation days. Not their sick days, by the way, their unused vacation days. So if you think you might be conducting layoffs, but you are not quite sure yet if you will be conducting layoffs, you think you will be, you don't know, you'd prefer not to, of course, you'd like to buy yourself some time. If you're going to conduct layoffs, you would have to pay out that vacation time anyway. By paying it out during a furlough, by saying, you know, you're going to take the next 2 weeks off and we're going to pay you using your vacation time. What it does is it buys you that amount of time, let's call it 2 weeks. It buys you that 2-week period to assess the company's economic position. And it might give you just enough time not to have to conduct any layoffs at all. Either way, if you don't lay anybody off, you might be feeling like, you know, when we open back up, we need all hands on deck. There might not be much work right now, you know, for various reasons. You might be feeling like we need all hands on deck. So if you mandate that your employees take their vacation time now, then, you know, when you do reopen, you will have all hands on deck once you open. So that is that is the answer.
Thanks. And while we're talking about decisions like this, how should an employer lay off an employee who is working from home should that unfortunate situation happen?
You know, so look, it's certainly preferable to speak with employees in person, and obviously that's not possible now. Because it's not possible, I recommend that employers replicate their usual process in digital format. Less ideally by phone call, more ideally by digital format. But now, if you haven't done this in a while, right? Like many employers, they have not had to lay anyone off in a really long time for various reasons. What should that process look like? Obviously, it should all be approached sensitively and compassionately. That's our starting point. You schedule a video call with 2 people present, one doing the talking, one observing. I personally recommend scheduling it on the very same day that you will have the call. And the reason for that is you don't want an employee worrying for 3 days why 2 supervisors have asked them for a video call, because that just sort of adds, adds insult to injury, so to say, right? You want to be conscious of you know, removing the employee's email access, phone access, database access, any access points they have, something to consider. You need to provide their final payroll on or before whatever day you would run regular payroll. Now, you are allowed to prorate their paycheck only for the days that they actually worked, but you have to be sure to pay out, as we just discussed, you have to be sure to pay out their unused vacation days. You can collect keys, cards, laptops, things like that. Obviously, in this climate, you would have to do that by mail. You can offer to reimburse. You should offer to reimburse the employees for any cost they incur to mail that to you. And then you provide a letter documenting the layoff, notifying the employee of their, you know, how to apply for unemployment benefits, offering to help if you feel able to do that. Many employers will choose to pay for some, you know, career coaching that employees can have going forward. And you should consider if you want to put in place some kind of separation agreement. And a separation agreement, essentially what it does is it gives the employees some amount of compensation which they're not owed. So in other words, you lay somebody off, you have to pay them for the days they've worked. That's non-negotiable. You have to pay them for their earned vacation days. But if you pay anything beyond that amount, which many employers want to do to help their employees, you can use that payment in exchange for a separation agreement which the employer, which the employee signs, you know, saying that they were not laid off for various wrongful reasons, and basically saying that they will not sue you.
Okay, before I turn back to Wendy, while we're on the topic of really tough decisions, can an employer require employees to stay away from the workplace if they've been exposed to the virus?
Uh, Absolutely. Not only can they, but they are encouraged to do just that. And you know, in this climate, you know, in many states, many employers, actually in all states probably, many employers are checking their employees' temperatures before they come in every day. That's like for you know, essential employees. They are, if you have people coming in because of the work you do, you can conduct health screenings, you can conduct symptom screenings, check their temperature, administer a COVID test, and of course you can ask these people, have you been in contact with any person who you know has COVID or who has symptoms of COVID? And if they answer yes, you are absolutely allowed to say, I'd like you to stay home for the next 2 weeks or whatever.
Thank you. Wendy, this one seems like it's more in your area. Are childcare teachers whose program is under the sponsorship and incorporation of a faith-based organization eligible for unemployment insurance?
Yeah, so that's an interesting question because it's just sort of an interesting thing that faith-based organizations often do not have to pay into the unemployment compensation fund. It's an option for them, unlike other employers that have no option. So in normal times, employees of those organizations are not eligible for unemployment. But again, under the expansion of the types of individuals who are eligible for unemployment under the CARES Act, those individuals should be eligible for base unemployment compensation through the end of the year and also for that $600 additional benefit through the end of July. I would encourage the employer to call and talk with the Department of Labor in Maryland just to confirm that, but that is my understanding as I read the DOL guide, the Federal Labor Department guidance that comes out under the CARES Act.
Also, Wendy, can you comment on, can employees get unemployment benefits if we reduce hours instead of conducting furloughs or layoffs?
So generally, yes. Employees whose hours have been reduced generally are going to be eligible for unemployment benefits as long as the amount that they earn does not exceed the weekly benefit amount available, that $430 in the state of Maryland. So, and one important thing for employers to keep in mind, if you're thinking about reducing salaries, is you want to be sure that you are not reducing the employee, you want to make sure that the employee is eligible for unemployment benefits in the state. So they would have to earn at least $1 of unemployment benefits. So you want to at least make sure that you're keeping whatever compensation you're paying them under the state's weekly benefit amount. Otherwise, they're not going to be eligible for that additional $600. So if you think about the $430, you want to make sure that the employee is not earning more than $430 from you, because if so, they don't get the base qualification for eligibility under Maryland's unemployment compensation. And if they don't get that base eligibility, then they are also not going to get the additional $600. The $600 applies only to recipients who otherwise would be receiving regular unemployment compensation benefits. So that's just sort of a strategic consideration. Otherwise, it's sort of the worst of all worlds. You've reduced their salary, but they're also not able to get unemployment. Another thing that you might want to consider if you are looking at reducing hours is your candidate, you as an employer may be able to apply for a work sharing program in the state of Maryland. So Maryland has a program that is basically designed to try to help employers avoid layoffs and furloughs. And you can basically reduce employees from full-time to part-time, and the federal government will pay the difference in their pay, or the state of Maryland through the work share program, for up to the 26 weeks. So there are some rules to this. It doesn't apply if the employee works on a seasonal basis, or temporary or intermittent. But for most employees, you can enter into a plan, and basically you will pay for part of that employee's salary, and then the state will make up the difference. The complicating factor here is you would have to submit a plan showing the number of layoffs that you otherwise would have to, that you would otherwise be making, and show how the work sharing plan is necessary in order to avoid those layoffs. And there are a bunch of other rules for how you submit the plan, but that's something to consider if that is where you were looking to go.
And this one, I'm not quite sure I understand the second part of the question, but I don't know if you saw in the chat box the question about 1099 contractors. The question many filed before they were eligible for unemployment. How do we handle these requests? Is that something you could speak to?
Yeah, I mean, generally speaking, now 1099s are eligible if they otherwise meet the eligibility requirements. So I would just encourage those people to apply again. And there are delays and it's a big mess, but they should, if they otherwise meet the qualifications, they should be able to receive those benefits now.
And I know you answered this somewhat, but the question was temporary employees, like at a school, subs, music teachers, library supports, can they apply for unemployment? And will this affect the PPP grant status?
Yeah, so the question was posed in terms of them being temporary employees. It's not clear to me when I think of subs, I think that maybe they're part-time employees. So I'm not sure which question we're answering. But basically, anyone should be able to apply either way. If they're part-time employees, then they would apply based on their part-time status, and whatever benefits they would be getting out of unemployment would be proportional to the number of hours that they typically work.
And I'm not sure if this is a Wendy or Isaac question, but does the leave due to childcare or schools being closed apply to employers of all sizes? And does it apply to part-time staff as well?
Sure. So there is a carve out. The short answer is it does apply to employers of all sizes. There's this particular carve out that for employers who have 50 or less employees, if complying with the law would threaten the viability of their business, then there is a process by which they would not have to comply. But keep in mind, you know, this leave program, the leave program is fully refundable to the employer through a tax credit. So how would this play out? Like I can give you an example that I've seen a couple weeks ago. Let's say you have a smaller employer, and one of their truly essential employees. This is well below 50 people. It's it's a very small team. One of the most essential employees says, "I need to take 12 weeks of this leave." Without that employee, all pay credits aside, without that employee working for the organization, they literally couldn't operate. They couldn't do what they do. So in that case, they were not obligated to provide the leave, because by losing this particular person for 12 weeks, it would very much put the viability of the business into question. Outside of that circumstance, this applies to employers of all sizes. And as to whether it applies to part-time staff, there are some requirements of, which, actually, I can check this and let you know. I knew the answer very well a couple of weeks ago, and I haven't looked at it since that time. But if Wendy happens to know, she can jump in. Otherwise, I'll answer by chat momentarily.
And also, before I lose you, this question seems like it's for you. If you reduce compensation for all senior staff, i.e. all exempt employees, and someone says they will go on FMLA, can you still reduce their pay, or are you stuck paying for them the full amount while they are on FMLA?
That's a good question. So I think it depends on the order of events. So if an employee qualifies for the expanded, family medical leave coverage because they're caring for a child who's home and not in school, um, if they make that request and then subsequently you cut their pay, I don't think that works. But if you do pay cuts across the board and a few days later somebody asks you to take that leave, then pay cuts are also subject to a notice period, right? So that's another important consideration. So assuming the notice period is met, and the time comes for that pay cut, I think that if they ask you first for the leave, then you cannot cut their pay while they're on the leave. But if you have made the pay cut subject to the notice period and then they ask for leave, then the leave would be subject to the reduced pay. If Wendy has a different view, Wendy, please feel free to jump in.
If Wendy, are you not jumping in? Okay.
That sounded right to me.
Okay. I didn't want to cut you off if you were. I'm actually going to ask Hannah to unmute herself if she's comfortable doing so, because you've asked your question in a number of different ways and I don't think I'm capturing it right. So do you want to go ahead and ask for yourself?
Yeah, I was going to say, should I just unmute? I'm looking at the request for separation information form right now. I have received this from 2 of our contractors, and the options for the reason for separation from employment do not apply to 1099 contractors because they are not W-2 employees. So there is not a reduction in their hours. They do not have a lack of work. It's not been a vacation, holiday shutdown. They were not hired part-time. So I'm wondering what it is that we do in this circumstance. Is that something that us as the employer need to figure out, or did the employee apply too soon and they need to resubmit their paperwork? Or the contractor, not the employee.
Yeah, so it's a great question, Hannah, and honestly, I don't know the answer to it because typically, as you said, 1099s are not allowed to apply for unemployment benefits. I think the answer might be one of 2 things, and I don't know whether there is guidance out there in the state of Maryland. I haven't come across it. It could be that either you received these forms in error because they are independent contractors and there shouldn't really, maybe they mistakenly listed an employer when they shouldn't have because they're self-employed, they don't have an employer. Otherwise, I would say maybe it is lack of work. If you've terminated their contract or you've suspended their services for this period of time, then if anything, it would be a lack of work. But my gut is that you shouldn't have received the form at all because you're not their employer.
That's what I was feeling too. I got one in March and she was not yet eligible to even apply. So I don't know how she snuck through unless she just said, I'm a W-2 employee, which she is not. So, I don't want to say, I don't want to honor the request because they should have access to these benefits, but I'm just not sure as the employer what it is that we're supposed to be doing with these 1099 folks who are now starting to come through.
Yeah, I mean, under ordinary circumstances, I would tell you to call the state. Unfortunately, they are so backed up that
I called like 47 times this morning.
I'm not surprised to hear that.
Yeah, and couldn't get even a ring. So
yeah. So, I mean, I might. I don't know. Maybe we can try. I don't want to take up everybody's time unless others have experienced the same concern. I don't actually know the answer to the question, and I haven't really had to advise employers on how to fill out that form, so I'm not familiar with what it says on the form. I don't know if there is any opportunity for you to explain that they're a 1099 and they're not a W-2, which should cut it off, or to provide any other sort of comments, which I'm guessing is not an option.
Yeah. I've been trying since March to when I got the first one, I started calling and I have not been able to get through to anyone.
So I'll tell you what, We are, Isaac and I are going to put our contact information into the chat for anybody who wants it. Why don't we follow up separately, and I'll look into it. I don't know the answer.
Okay, thank you.
And let me, if I can just jump in with one final point. Absolutely, please do follow up with us, and we will send our emails shortly, and Wendy can help you with it. Right, not so far from you guys in DC, I dealt with a similar issue not very long ago, and basically here was the outcome. DC had not yet updated their forms to reflect the new program. So as a result, everybody was trying to use the old forms to apply for a completely different, a very expanded program that isn't reflected on those forms. I suspect that what you've run into is that, and certainly reach out to Wendy, and she'll give you some guidance as to how to respond. My instinct is to include some kind of letter to explain the situation when you submit that form.
Two quick things. I know we're bumping up onto our end of time at 3:30, but Wendy, Hannah, it looks like Baleen at Identity has had a similar problem, so you two might want to chat too. And I just wanted to quickly ask, and hopefully this is a quick one, there was a question about retirement. Are we legally allowed to cut benefits like a retirement match?
So my suggestion there, and Isaac, you may have different thoughts, is that typically your retirement plan documents are going to govern what you can do, and those, as you may know, are governed by a federal law called ERISA, and so you want to be very careful. I don't know whether there are specific guidelines for that. We typically work with one of our colleagues who is he's an employee benefits lawyer, and that's all he does. But my general sense is that you probably cannot make cuts unless your plan permits it. So you may also want to talk to your benefit plan provider. Isaac, I don't know if you've got anything else to add on that.
I agree with everything Wendy just said. Definitely talk to your benefit plan provider. Some of these plans depend, and again, this is not sort of my area of expertise. We have someone that is his area of expertise. I am not that person, but some of these plans that I have seen, what they say is for 2 out of every 5 years, the employer has the option not to make a contribution. I have no idea if this is your plan, but some plans are written that way. So I would just contact the plan administrator, and they should be able to tell you exactly what options you have.
Just wanted to thank Wendy and Isaac. Really, this is a very difficult time for lots of people for lots of reasons, but it's nice to have these sort of ports in a storm and people willing to share their expertise. So thank you both individually, and also to Potomac Law Group for offering this to our members. We're very lucky that you're able to do this, and we look forward to continuing to talk to you in better times as well. Thank you all. And I have recorded this, so if anybody would like to look back later, please feel free to do that, and I'll send a follow-up email as well. So Wendy and Isaac, if there's anything later on that you'd like me to share with the group, just let me know.